that's another rather large district. That looks like City of Kentwood and going down into Gaines, and that also runs into, you split Gaines Township, which was one of the comments we had. So just, that seems like it would be a larger district and then splitting Gaines Township.
Well, sure, but again, we have a range with which we have to satisfy the variance in the population. We're not going to get exactly 31,000. Some could be more, some could be less, but as long as the variance is within that threshold, it's acceptable.
Okay.
So it meets all the requirements of the statute and the case law that I've read.
Okay. The other question I had, and this is jointly, I think we heard the comment from the Wyoming City Commissioner about kind of splitting, you both split Wyoming into a number. I didn't exactly write down exactly the differences. Can you explain that, I guess, to us and maybe answer some of those questions on, they had a request definitely to keep it at least two within the city of Wyoming, and neither of those does that. Can you explain that?
Well, I believe that, so Wyoming requires a minimum of 3 districts, I believe. 2 can reside within the district completely itself, and then due to population reasons, you have to put a part of Wyoming somewhere else. So that's just the numbers, the way the numbers work. And we tried to, again, at least put 2 within Wyoming because, as I believe, excuse me, Commissioner Fitzgerald said, it's the second largest city within within Kent County, and it made sense to just keep 2 of them there and then have to put a section of it somewhere else.
And my only addition is that part of the Wyoming combined with Grand Rapids creates the Hispanic district.
Okay, all right. I guess kind of the final thing, and this may be for council as well, like I sent out that question this Sunday, and this specifically the Saxton plan in terms of, you came up with the cornering. I'm concerned about District 4. You have Algoma and Cannon with Rockford acting as kind of a bridge. And I guess maybe Mr. Saxon, the reasoning for that, maybe what are your opinions in terms of the legality of that, given you said, I didn't see the case, but something about cornering as being not as contiguous, is that going to be a problem? I'll let you go. Mr. Saxon, sorry. I guess I'll ask you maybe your explanation for it, and then I'll ask him is there an issue?
Yeah, so there's no cornering involved in that. There's clear boundaries that connect the township with Rockford, so that doesn't apply.
Yeah, I think the case where that issue actually came up, the actual corners were touching.
Okay, yeah.
And so they did, I think that's part of District 1, right? Where it kind of goes down a little bit here.
Hey,
I think
Troy,
that's.
can you hit your button?
Try to hit mine.
Sorry. Okay, sorry. Yeah, so the case that talked about cornering, I think it was literally just the corners touching.
And that's, okay, I wasn't familiar.
Yeah, and I think, Mr. Chair, that part of District 1, I think in that, up there, I think is enough to say that's not cornering, based on the case law.
Okay, well, that's just, definitely I didn't know if that was enough, because clearly, it is connected by Rockford, but I didn't know if that was considered cornering.
It's close,
Okay.
yeah. I mean, we could look at it closer, but, yeah.
Okay, all right. Those are my questions, I guess. Does that bring up any other questions for anybody else? Ms. Lyons?
Thank you, Mr. Chair. I definitely don't have a question, but I understand residents' feedback when it comes to splits, particularly among their townships, and I appreciate the responses from both individuals who have submitted their plans as to how and why those occurred, and I think it's inevitable that there will be some split somewhere. But I want to just kind of broach, and I don't know what you guys have planned, if you have any amendments planned, but I was very receptive to former Commissioner Talon's remarks as it relates to neighborhoods. If those neighborhoods within the city are in different districts, I would just encourage maybe exploring the possibility of bringing some of those neighborhoods together if it's possible. Again, it's not part of the parameters. Certainly that would invalidate a plan, but if it's something that we can make work, maybe that's something that could or should be explored. Although I know I don't know if you have amendments to put forward today or Friday. We can obviously discuss that at that point.
Bring up then, anybody else? Ms. McGregor, I know you're at home, but just making sure we're not forgetting you. You can hear us and everything, right?
Yeah, I can hear everybody clearly. I have no comments at this moment.
Okay. I guess at this time, are there any map amendments that anybody wants to put forth at this point in time? Nothing. Okay.
I don't have any to put forth at this time. I'm trying to look at that community, those neighborhood communities. It's challenging. It's challenging because following the statute, the most important is that every voter has approximately the same power, the same influence, so we are trying to maintain that equal population wherever we can. I am exploring whether we can incorporate some of those. I think he made reference to the Grand Valley has those neighborhood associations, the boundaries online, so I'm looking at it. I don't have anything to present today. I will, if I'm able to put something together, an amendment to accommodate that, I'll try to get it to everyone as soon as possible, because I think the challenge with a Friday schedule, if an amendment comes in Friday morning, we won't have an opportunity. Certainly the author of the amendment will have vetted it through the various tests under the statute, but I think it's important that we get those amendments in front of the members as soon as possible. So I hope to certainly no later than tomorrow afternoon would alert people if I have one.
Well, I guess that brings up another issue that I was just made aware of about a half an hour ago about a possible issue regarding our current schedule. So, Ms. Lyons, why don't you bring that up and share a little bit?
Okay, I would like to take us all back to our first meeting where we discussed the timeline, and it was where the 60-day deadline begins, whether that is when the federal government released the census data on August 12th, or would it be the state's interpretation of, at that time, September 30th, which then turned into September 16th, I believe, because they uploaded their information to the state redistricting tool early. So this body, with the legal opinion that we sought from, we provided from my County Clerks Association, authored by John Lauterbach, determined that August 12th would be is the deadline based on the statute, and therefore we would have our maps done and submitted and approved by October 12th. In that meeting, after we had made that decision in a motion, Mr. Saxton, you did ask if, when we adopt this proposed schedule and more clarification is given in the future, if we could modify that. And I think that was the intent. That was the intent of this body after affirmation or confirmation from our legal counsel at that time that we could indeed review that. Since then, and particularly over the last several days, and this issue has really seemed to bubble up into the surface about there continues to be a question of should there be a legal challenge with an unpredictable court if they deemed that our legal opinion is in fact not what they would interpret the law to be, and that September 16th would be the beginning of the 60-day time period. There is concern that if we adopt our map prior to the August 12th or the October 12th deadline, it could invalidate that map because, as you know, statute requires us to approve a plan no earlier than 30 days, but no later than 60 days. If we adopt our plan on the 9th, as we should, I believe, of October, we run the risk of, if a court somehow determines that the deadline is really, the shot clock began on September 16th, we are prior to that 30-day window, 30 to 60-day window. Therefore, what several other counties are doing and what our legal counsel has advised is seeking an, petitioning the Court of Appeals for an extension, so that we can make sure that we are in full compliance with the statute. I believe it's really kind of a covering all basis measures. I know I've heard there's probably 15 to 20 counties who have made this same petition. And so I guess I bring that up to you, and I can turn it over, Troy, if you have anything to add. I tried to lay it out as thoroughly as possible, but if there's any questions or discussion on that.
Yeah, I think the only thing that I would add is like Lisa said, there's no, yeah, I think it's on, right?
Sure.
There's no way to reconcile those two dates, and we feel very strongly that October 9 is the date that we should have it in by. But because the Bureau of Elections.
Yes,
October 12th, but that means really.
Our schedule.
Yeah, our schedule, October 9, right. Since the Bureau has taken a different view of that, that really complicates things, because they're really viewed as, they have a lot of authority in this space, and so I think we're right, but there's just no reason to take any risk in my opinion, and so joining, in with the other counties that have requested, it's a statutory provision that allows for us to petition the Court of Appeals for an extension. I think Ottawa County just did it and got it within a day or two of filing, so it's a very quick extension that gets granted, and if we do it today, we could probably, hopefully, get an answer by Friday, so we would know, and then I think the next step that you didn't talk about yet is then we could kind of push Friday's meeting out to October 18, and then we would be in compliance with the extension, and if a court came in and said that later date is the right date, we'd be in compliance no matter what. So that's what the proposal, I think.
Yeah, we could set it doesn't have to be the 18th, it would have to be, between the 18th and November 15th, I
15th,
think, something
yep,
like that.
right.
I do also want to point out that this was an option that was presented in the legal opinion that Mr. Lauterbach provided. However, it wasn't something at that time that we were really focused on, because I think it was very adamant that based on the statute, that October 12th would be the deadline. But it's not something unheard of, and as you said, the statute does provide for that.
Mr. Hewlin.
Thank you, Mr. Chairman. A question for our council. If for some reason the court does not act prior to, let's say, Monday, which would be the other date, the date by which, assuming the Clerks Association's counsel is correct, should we schedule a meeting for Monday morning, because we won't have the assurance that we have an extension, and we'd have to face the difficult.
It would be my recommendation that if we do not have a judgment on our petition, or a ruling on our petition by our meeting date Friday, it would be my recommendation, or my preference, that we keep our Friday meeting, and another option we have is go as planned, and then come back and re-adopt the plan within that other time frame. That is something that has been made available as an option to counties as well. More people are choosing to get the appeal rather than go that route. It's kind of clunky, it's not pretty, but it is allowable.
So Mr. Chairman?
Please, yeah.
So if I understand what you're saying is that we will ask council to seek the court extension. If it does not occur prior to Friday at 10, we will meet, we will adopt a plan as originally planned, and then if there's additional clarity and it looks like we should have delayed, then we can reconvene and re-adopt the plan, and that's fully in compliance with whatever statutory requirements. Is that correct? There's no downside in adopting a plan on Friday and then re-adopting it in the window?
If we don't Have a petition.
I don't know that it's been done before, but this is a unique situation based on what the Bureau did, so other counties, I think, are doing that, so, yeah.
Well, we could, if we think the order may not come in until after 10 on Friday, we could reschedule our Friday meeting to Monday. You don't want to do that?
I'm sorry, we can. We absolutely can. I know we have one member who wouldn't be able to, actually,
Mr. McGregor is raising his hand. so
Yeah.
maybe
Oh,
that's-
I'm sorry.
And, one comment before we get into the scheduling, I'd like to ask council is, has a Court of Appeals ever denied a request? Is there any reason to think that we would not get this request, confirmed, this extension?
No, not in our opinion. The statutory requirement is you need to have good cause, but every county that has requested the extension so far has made a very strong good cause case, because we have the Bureau telling us one date and legal interpretation another date, and so we're in an impossible situation, and that's good cause for the extension. And every judge has, I think the Court of Appeals has granted every extension quickly.
What are the, I mean, yeah, within a day, I mean, that's Court of Appeals, yeah,
It
I know in the
depends.
courts, yes.
So if we're given the direction to do that today, we would file it ASAP today and then put a lot of pressure on the Court of Appeals, try to expedite things as much as we can. You know, it's a process, but it should be fairly quick,
So
within a
if-
day potentially.
Yeah, the only reason and if there's a conflict with a member on Monday, I'm fine holding Friday. My only thought was,
One more
I
day.
have little faith, I don't have as much faith in the Court of Appeals being that responsive.
I'm right with you.
But if, and it, I think our, Ms. Lyons referred to it as quirky. I like to avoid quirks if we can, but I'm fine meeting on Friday as per the original plan. Get the judicial relief process initiated ASAP, and maybe we'll hear something tomorrow.
Is there any way, I mean, if we could push that Friday meeting back to the afternoon to give them more time? And that's the only, because, you know, that's, basically, it's 48 hours, you know, 10 o'clock, that's really, you know, I'd be shocked if the Court of Appeals responds, but I have heard they have. But can we do it a Friday afternoon just to give it because I personally do not like the option of voting and then coming back and giving a stamp
Ratifying,
of approval, because
yeah.
that, to me,
Is clunky.
it's very clunky, and I'm worried about the Court of Appeals, and we're kind of in the same boat as what we're doing right now, it's just a sham. I'd like to do this
The-
as close as we can to what we're gonna do. So if we can schedule our meeting Friday afternoon at some point in time, to give it as much time as possible, for that.
Yes, I mean, we could even go on Monday, it would just, my preference would be same thing, it would have to be in the afternoon, simply because I have an election audit to attend in the morning. It's kind of a big deal.
Well, maybe the middle ground is Friday afternoon, make it 3 o'clock Friday afternoon, and that works, if it works on everyone's schedule, that gives the court a little more time to,
Can we do 3:30? I have a victim witness meeting, it should be a very brief one, I just gotta explain something.
But can we do it earlier, at 1? I don't mind pushing it back a little bit. 1 o'clock would be ideal for me.
I got a board meeting at 1:30?
Is there something wrong with Monday? I mean, initially I was concerned about Treasurer McGregor, but I remember he has his medical exemption continued through Monday.
well, I think Monday,
That's-
then we don't have to, then it reduces the likelihood we're gonna have to adopt 2 plans. I should probably look at Monday.
And I would say if we did it to Monday, and then we could cancel it, if we do get the extension, we could cancel and reschedule to the week of the 18th or whatever.
That would be ideal.
Mr. Chair?
Mr. McGregor?
Yeah, I was wondering, I would suggest we keep, Friday, just in case Troy can, do his magic and we get the result back in time, and then also schedule for Monday. Or have some contingent Friday meetings and get this done, at whatever time we decide amongst, the committee on Friday, and then also do the contingent Monday.
if he gets the extension, we wouldn't need Friday, right? Or Monday. So we were scheduling Friday as the absolute last ditch, just in case he couldn't get the extension.
But then we're considering, instead of Friday, allowing for that business day to occur so that it provides the Court of Appeals that much more time to consider our petition. So essentially, in a nutshell, what we're discussing is, instead of meeting Friday, moving our Friday at 10 o'clock meeting to Monday. Is that something you're okay with?
Yes.
Okay.
Monday work for, is it?
What time did we decide?
We don't have a time, we're just is Monday okay?
Monday
Is
works.
Monday okay, Mr. Saxon?
Ideally, for me, it would be after 10:30, so I can attend my audit, but if
After 10:30 works for me.
Did we say Monday afternoon does not work?
I prefer not the afternoon. After 10:30 works for me, at 10:30, 11 o'clock,
So
those,
11 o'clock on Monday?
Yeah.
I can do 11 o'clock on Monday.
Now, that was some logistical magic right there.
So we will cancel our meeting on Friday at this time, and we'll set it for Monday at 11. If for some reason we get it's adjourned, then we'll cancel that Monday meeting too.
Yeah, if we get the petition, yep. We will post that meeting in compliance with Open Meetings Act, just as we have every other meeting. And should we get the response, the ruling from the Court of Appeals, prior to that, we'll issue a notice of cancellation as well.
Do we have to get back together as like an open meeting to schedule the next meeting? Let's say, assuming we get that, then we can just put on the 18th and we'll even exchange emails or something. We can do that, that's okay?
We meet at subject to the call of the chair,
Okay.
Mr. Chair.
There we go, all right.
Do we need a motion to that effect?
Yes, Mr. Chair, I would like to make a motion that we ask legal counsel to file a petition for an extension in the Court of Appeals.
Do I have a second?
Support.
We have a support. We have a support and a double support. Any discussion, any further discussion? All those in favor say aye.
Aye.
Any opposed? And it carries. Okay, so we got that set.
and clarifying Friday is canceled.
Friday is canceled.
Indeed.
Monday at 11 right now. Tentatively, we'll assume, probably that's gonna be canceled too, assuming we get that back by the Court of Appeals.
Do we need a motion, or if we meet subject to the call of the chair, chairs?
I think if we say meet subject to my call, I think that's fine.
Okay.
Can I raise one more issue?
Please.
I think,
Oh, good.
I don't know,
What if we say no?
then I'm quiet. All right. I think you set a deadline for Friday for amendments. Or do you want to keep that date, as the deadline?
point.
I mean, I would defer to the submitters of their maps, but I do think, especially if we've moved the meeting to Monday, I do think that gives us a clear, if we keep our deadline to Friday, that gives us a clear ability to be able to review those and come better prepared on Monday, so that we're not given amendments and then expected to vote immediately. But again, that's my thought, but I would defer to the two submitters.
I'm fine with that. Keep the deadline Friday. That way, if there is an amendment, it gives us the weekend to evaluate it on the assumption we Monday. If we don't, I think we've had the time to vet the maps, that gives us adequate time to consider amendments. So I would propose we keep the Friday deadline for amendments.
I mean, nothing's preventing, I remember having this discussion in the very beginning, in that, if this didn't happen, and we had Friday meeting, the Friday meeting did call for amendments and adoption. I don't think that changes with moving it to Monday, honestly, so people are free to offer amendments up until Monday, as far as I'm concerned, up until whenever we adopt, because that's kind of what we agreed upon, initially. So I don't think moving it to Monday changes anything as far as whether amendments or adoptions are allowed or not. People can submit whenever they want. So, I would just say that it's no different than it being on a Friday. People are free to submit amendments. I don't foresee any drastic changes or anything like that coming on Monday, but they should still be allowed, just like they were on Friday.
So kind of two opposings.
Well, no, I think the issue is, having an actual deadline
For
for
the-
it, and that's what, like, to have enough time to review. But as you mentioned, like, that doesn't prohibit anybody from sending any amendments, right? But it's past the deadline, right? So it's gonna be less time for us to review, or you to review that. But having a deadline, I think, is still good, because try to get it in by that time, we'll have enough time to review it. Of course, somebody could submit something at 9:59 or what, a minute before our meeting. It's hard to review an amendment right before the meeting, but somebody could do that.
So essentially, we'd have the deadline as an ideal, and obviously no prohibition after, if something's submitted after.
You don't have to, consider it if you don't want to,
But we can if we'd like to.
of course.
Yep.
And I think for the submitter, whichever one of us it is, realistically, the earlier the proposed amendment is submitted, the more thorough evaluation will occur. If I submit a proposed amendment at 9:59 before a 10 o'clock meeting to adopt the plan, it wouldn't shock me if the other members would say, well, it's fine, we'll consider it, but we don't have the data, we don't have the time and to evaluate it. So I think we both need to know that if the earlier we submit a proposed amendment, the more thorough evaluation it will be given by the board, and more, I'll say, credibility, but the ability to thoroughly vet it, which is, we have the statute, we have to see how any amendment would impact the various guidelines set forth in the appropriate statute.
I mean, if we receive a last-minute amendment, a recess, a temporary recess of this body to review it may be in order even.
Mr. Saxon?
Yeah, and my other question is, the process through which we have submitted has been at a meeting, where we passed it out and submitted it. If we don't have anything scheduled between now and Monday, what is the process for submitting something earlier? Is it emailing everyone? Is it, let's call a meeting on Friday, Mr. Chair?
I don't have a problem with an email. I mean, that seems to be, we've exchanged some of these meetings via email. I think, we've got the basic plan, so if there's any amendments, I don't see a problem with email. I don't know if that violates anything, Open Meetings
No,
Act.
no,
or-
it does not. You can submit it via our apportionment email address. I think that's how you submitted your map. So, I mean, unless there's a strategy why one wouldn't, but that's definitely something that we set up in order to be able to accept input, amendments, and submissions.
Okay, so then, am I hearing we're keeping Friday, because Friday's technically kind of was supposed to be our meeting date, but that's kind of the deadline for amendments and email, being submitted by email. Do we have a time? Is it gonna be the meeting time we had at 10, or Friday close of business?
I think, Mr. Chair, we said with respect to plan submission, it was the time of the meeting. So it should be 10 a.m. Friday morning. That would be my thought.
Oh, no, I'm against setting any kind of, because I don't even know if it has any power. Somebody could submit something. And then on top of that, if we do get the extension, which we're hoping for, this puts it out till the 18th or whatever we decide. So I mean, we can all decide whether or not something's submitted on Friday or Monday and take that in consideration when we're adopting something. So the same thing that when I voted against the October 12th deadline, I just didn't know about it, but we all aspired to do it by then. And it looks like we would be able to. So, yeah, I'm not for setting any artificial deadline. We have a meeting, we're gonna adopt. If somebody wants to submit something, we can take that and the time of that submission into consideration if we want. That would be my thought.
I tend to agree with
Yeah,
that. I think there's something to be said about that, in terms of, going to your point, though, if you do it at 10:59 or whatever day, whether it be the 11th or the 18th or November 6th, because it gets pushed off again, because who knows why. It's just gonna be how hey, we don't have time to review this. We got one that we've had over for 2 weeks, been able to hash it over.
Yeah.
Sorry. I agree with that. So it gives you more time to work on things too. You're not rushing to do it by Friday. So,
I'm okay with that.
okay.
I have no objection to that either. But I do want to clarify, it was my understanding that we were replacing the Friday meeting with the Monday meeting.
Correct.
Okay, so we are not having the Friday meeting.
We're just using that as kind of a time,
Okay.
was there and now it's
But now
not a
it's not.
deadline. So Friday is done.
All right, well, enjoy your Friday.
Friday is done.
Monday is a potential only if we don't get the,
I would rephrase that to, Monday is our meeting date until and unless
Till further
we,
notice.
yeah.
And I guess we'll make it clear on the record that, if you want to do an amendment, the sooner you get it in, the better. Because if it comes in late, we may not consider it at all. We may, but, the earlier we have to review and go over things, the better. So it's clear and make sure that's part of the minutes that we put out there and, okay? All right. Any further discussion on this?
Please no.
Do we have any public comment at this time? You moved, so I was waiting, so. When you move, so, yeah, okay. Seeing none, I will take a motion to adjourn.
Move to adjourn.
All those in favor? Aye.
aye,
All right, we'll see you sometime.
keep us posted.